So welcome all to the first Belgrade Legal Theory Group meeting in this academic year. The meeting is special for a couple of reasons. The first reason is that we find ourselves in the new rooms on the Faculty of Law, University of Belgrade, that were made for these specific purposes, for the purposes of doing research in legal theory and philosophy of law. And the second reason for the claim that this Belgrade Legal Theory Group meeting is special is that it will be moderated by our recently new colleague, Julieta Rabanos. Julieta is with me here. She's on her postdoc. She arrived from Genoa a couple of months ago for her postdoc on the Faculty of Law, University of Belgrade. So I'll leave it to you, Adam, Julieta.
Well, thank you very much for the presentation. I will now introduce the speaker of the session. That we can see you, Adam. You managed. So we can see both. Yeah, exactly. Fantastic. So I will introduce you and then I will give you the floor. So Adam Dyrda has an habilitation and a PhD in legal theory and a PhD in philosophy. He works on epistemological issues related to epistemology of disagreements in jurisprudence, social ontology and ethics of belief. He specializes in Anglo-Saxon legal and philosophical thought, general jurisprudence, analytical philosophy and pragmatism. He works at this moment in the Department of Legal Theory at the Jagiellonian University in Krakow and is member of the Jagiellonian Center for Law Language Philosophy. Is also a guest editor of Synthesis, Topical Collections, Evidence in Law and Ethics, former, and Ethics of Belief in Natural Science, Social World, and Philosophy, current. He published over 50 publications, including ones in volumes by Oxford University Press, Edward Elder, Harter Springer, and journals such as Jurisprudence, International Journal for the Semiotics of Law, Erasmus Law Review, and I'm so sorry, I cannot really pronounce this, like Archivum Philosophiae, bravo, in philosophy, and I cannot pronounce it, it's Poets. Yeah, the Polish IVR journal. So sorry for this butchering of the pronunciation of the Polish. Adam, the floor is yours.
Okay, guys, thank you very much. First of all, for inviting me. Second of all, for this introduction. I must say that the topic I'm gonna talk about is not directly connected to things you mentioned. It's also not directly connected to ethical concerns that I've been working on, but I believe that in the end of the talk, you're going to see that there might be certain connections. The topic of kindness in jurisprudence is a kind of exercise in categorization or basic ontology for jurisprudence. And what I'm going to do today is to present you a couple of views that I find quite appealing with respect to some fundamental categorical choices in the domain of science or the domain of inquiry in general. And then I'm going to talk a little bit about how this kind of choices are applied within the domain of jurisprudence, or at least I'm going to discuss one of the proposals made by Mohammed Ali Khalidi and Liam Murphy from New York, who in one or two papers tried to apply a kind of or provide a kind of general structural argument for kinds or legal kinds, and also discuss the idea or the conception of law as a kind, a special kind of natural kind and social kind at the same time. So without further ado, let me just get to the first important point I want to make. The first important point is about different understanding of realism, because when we think about kinds there in the world, generally in ontology, we are usually committed to something that might be called realist thesis, namely the thesis which in its weakest form is simply the statement that there is a mind-independent reality. But in this weakest form, there is no further commitment as to whether we can really know this kind of reality. So certain further qualifications could be made in order to strengthen the thesis. So in a kind of strong version, if we think about metaphysical realism, we would have the following. There is a mind-independent reality, and we can learn something about it. But still, perhaps this kind of thesis is not strong enough if we want to learn something about the world, simply because from this point of view, there are at least two choices. First, that the world is some amorphous, not structured whole. And the second, more qualified realist thesis, that the world is something what is basically structured. And here we come to the main idea, which was introduced by Plato himself, the idea of carving nature at its joints. So in one of the dialogues, Phaedrus, there is this idea of, let's say, what's called nowadays a scientific butchery of the world, namely the idea that we introduce our categorizations, and if we are good, like butchers when they do their job, when we divide things in this category by means of these categorizations by classes where the natural joints are, and when we are not trying to break any part after the manner of a bad carver. So we are supposed to be good carvers, and then we are good philosophers, good scientific men, when we use our scientific knife to carve the nature at its joints. And in this context, we can say that this idea of kinds, or Plato's forms, because Plato used the idea to defend the domain of forms, are a kind of meat between the joints, right? There is a few platitudes we can say related to this. Plato also said that with respect to what he called the form, but I'm going to use the word kind, there were certain qualifications for him, like that there were things that are instantiations of forms, so there were instantiations of kinds in a variety of contexts, he said, to quote, in different regions of the world. He believed that forms are inherent of things, so things belong to certain kinds, which are sets defined by forms, so sets of properties or something like this. At most, one form corresponds to the multitude of things of the same kind, he said. But he also argued, which is kind of intriguing if we look at it from the contemporary point of view, that there could be empty forms, or things that do not correspond to any form, like particulars that do not have any general description. But the main point that Plato made was that these forms or kinds are supposed to be non-arbitrary multitudes, namely things that belong to one form are collected as a set, and they are connected in a way which makes them belong to the set, which contributes to their own or refers to their specific identity. So this set is, or members of the set are not selected arbitrarily. So he said that we are in a habit, this is a quote from Socrates, I take it, of posting a single idea or form in the case of the various multiplicities to which we gave the same name. And contemporary, we usually say, or philosophers of science or art, or of natural kinds and also of artifacts, say that we usually refer to kinds in general, or forms in Plato's version, when we want to make any generalization that is suitable for explaining something in a law-like manner. So kinds serve as nomic predicates, right? They categorize the phenomena, they help to manage the reality by means of the theory. But obviously, Plato is not the only reference here. One other interesting point about both realism and forms or kinds, as I referred to, is that actually and typically there are two types of kinds that are distinguished, and both Plato and Aristotle actually say that, well, there are certain kinds that are legitimate in a say as objects of scientific or serious genuine inquiry, and there is another kind of kinds, let's say, which are not too good an objects of such a genuine inquiry. So I already said something about natural kinds, which are those carved out of the nature somehow, but there are also artifacts that exist not by nature, but that are created by craft, by people, by some craftsmen. And these are artifacts, objects made intentionally in order to accomplish some purpose. Well, there's a whole discussion about what are artifacts, what is the genuine, let's say, substance which make or by which artifact is an artifact and not something else. But the main argument made by Aristotle, and actually argument that was made also by Plato, maybe a few times he slipped in his dialogues and made bad examples when he referred to artifacts as having certain types of forms. And this is why often when we talk about ideal forms or ideas, in the case of Plato, we refer for propedeutic reasons to chairs and beds, which are obviously artifacts and not natural, let's say, forms. But apart from this slip, which was for, as I say, for educational reasons, even in Plato, they both, Plato and Aristotle, believed that artifacts do not have their own nature or form because they had no essence. And actually, there's a quote which explains why it's the case. Namely, Aristotle wrote that things which exist by nature, such as animals and the organs of this, or plants and the elementary stuff, like atoms, for example, have in them a principle of change or rest in respect of place or growth and decline or alteration generally, the nature of a thing being the source or cause of non-accidental change of rest. And this is the idea that is shared by many, that there's certain kind of essence or some kind of force or principle that governs the way in which natural kinds behave, which is not the case, as Aristotle says, with artifacts. And also important idea is that even Aristotle saw that there are no specific principles that govern artifacts in this respect, because if anything, they are reducible to natural descriptions. So if we think about artifacts, the idea Aristotle had was kind of idea of scientific reduction. So whenever we think about artifacts, we can always say that, well, they are governed exactly by the same rights by which natural kinds are governed. Our only way to discover this is just to think of artifacts as combined of certain configurations of natural elements, right? So there are just principles of change governing the matter that composes them, right? So there are no special rights or laws of nature governing the behavior of beds and chairs and other artifacts, pens, or whatever. There are just general laws that govern the way in which natural kinds behave. But there's one problem that's been discussed also for some time. So there's a claim in literature, and actually it's quite plausible one given the abundance of the number of examples given, that this divide between, let's say, artifacts and natural kinds is actually not clear, not a very clear one, and also that most or many properties that we associate with kinds are shared by artifacts on the one hand and in reverse. So, for example, and there's also another problem, just to mention that there are lots of types of artifacts that are not only made unintentionally, but also they're produced by non-humans. So, for example, non-humans produce artifacts. There are examples of spiders' webs, beavers' dams. I don't want to get into this topic, but if you like semiotics, you could simply read some of Charles Sanders Peirce's writings on the University of Science, where actually what intentionality or having an actual intention is of secondary importance to recognize something as meaningful and made in a way. So there are also human non-social kinds and non-human social kinds, which are not artifact kinds. There are many examples showing that there are kinds of human-made things that are rubbish or scrap, which is produced unintentionally. But the problem comes with respect to, let's say, unintended byproducts. For example, we can think of indirect consequences of humans making certain artifacts, and further consequences might, for example, reach or lead to some unintended further phenomena like global warming. Right? There would be no global warming if not the whole cultural, artifactual reality humans built in the in recent 2 centuries, for example, one might claim. There are borderline cases like paths which might be created intentionally as well as unintentionally, like a result of someone's behavior, some animals' behavior, and so on. There are modified natural kinds, modified by means of genetic engineering, for example, where modification obviously is kind of a matter of degree. But I'm also talking about simple modifications, like making a hammer out of stone. That we have continuous or double functions of certain kinds, which might be perceived as natural from one perspective and cultural from other perspective. And this biological artifacts or domesticated natural kinds, like my cats, as discussed by Sperber, are good examples of this. But what's most interesting from our perspective today, and I'll get to this later, is are those non-tangible abstract artifacts, as they are called, like musical performances, scientific or philosophical theories, legal systems, legal persons, institutions, and so on. The interesting point about Aristotle is that he's not thinking of these artifacts as serious, let's say, subjects of philosophical investigation on the one hand. On the other, we know that in many places he discusses different forms of government or institutional ordering. So there's something, there's kind of, let's say, at least double vision in Aristotle about this point there. One might, or this is what one might argue. The one point important to make now is that it's before of this nature-cultural continuity problem. There are, at least in now new literature, there are two strategies, two main strategies, as I think, that are taken to deal with the problem of whether we really need these artifacts, and also whether we need these real forms that are supposedly referring or are supposedly connected with the idea of natural kind. So one way is the traditional way, right? This would be it would be to defend essentialism, or a form of essentialism in case of natural kinds and artifactual kinds. There are lots of theories that refer to different types of functions, both in biology and or evolutionary theory, and by analogy quite often in theories of artifacts. Some talk about intended functions. There are also actual functions or descriptive functions, as they are called. One interesting problem is whether functions are extrinsic on this or intrinsic to certain kind. For example, what would it mean? Well, it depends on the perspective, obviously, whether we like to discuss the kind in the wholeness of its relations with environment, or whether we focus on certain let's say characteristics or properties that are internal to the kind, not necessarily in connection to the whole environment. But the question is whether we can cut in a precise way in this as well. The important point is that in these essentialist theories, the sameness of function of an object is the relevant criterion of kind membership, right? So there would be, as I said, functional analogies between biological and artifactual kinds. It does not necessarily mean that the idea of essence is exactly the same, because it might be different in case of artifacts or in case of biological kinds like species, for example. But still, one can argue that at least extreme cases of natural kinds and artifactual kinds, like examples like atoms and atoms and abstract norms, result from differences in kind between these two types of kinds. Namely, this is just a matter that we actually impose a kind of a categorization norm saying, well, okay, there might be differences, but still we can see certain similarities, because as you would see later, the important idea of grouping kinds into subkinds, let's say, is about seeing relevant similarities. But the problem with essentialism is that kinds are prone to change, functions change. If we even think about pragmatist approach to any phenomena like Dewey or evolutionary approach, which also shares many elements with this, we would see that there is this connection, that there's always kind of reciprocal, let's say, feedback between the kind in question and environment. So kinds change. It's like just like species evolve, we can say that certain kinds, also kinds of artifacts, evolve. So and the idea of essence, on the other hand, is a kind of idea of something stable, non-dynamic in a way. So this is one reason why things should not get fixed. We should not get fixed on essentials. But there are many other arguments I don't want to get into. The second way is to withdraw kind essentialism, right? So we can redefine natural kinds so that we wouldn't have an, let's say, essentialist approach to kind, and maybe follow the Aristotelian lead and try to get rid of artifactual kinds as much as it's possible. Since we could always argue that, well, even the social world, of even in the domain of culture, we're gonna have various kinds of natural kinds that are carved because of the interests that we have, that are dependent are stemming from the let's say general idea of science that we're trying to pursue. So there would be different kinds on the level of biology or physics, and different kinds on the level of social sciences. And jurisprudence would be just another instance of kind of interest driven domain in which we could or would carve certain types of natural kinds, so to say, and structure our world or our theories accordingly. There's a lot of interesting insights made since John Stuart Mill on this. So, for example, so in the last 2 centuries, actually. So, for example, how do we carve kinds, which are real kinds or natural kinds in John Stuart Mill approach? So, first of all, we refer to paradigmatic kinds, like chemical species, chemical compounds, or biological species. But this does not exhaust the possible ways in which we, let's say, categorize the world, obviously, because according to Mill, we also have social kinds. The most important thing about natural kinds in general, or real kinds, which is the name he used most often, was that these are objects divided into groups whose members have a large number of properties in common. He also said that, we use these categories of natural kinds to capture things which could not only play a role in further explanation or putting forward certain hypotheses, but also to introduce categories which are, let's say, inexhaustible in a way, which would play a role in the further development of science, in his view, forever. And he also noted that this kind of categories are important in some sense, but obviously, as I mentioned already, relatively to the nature of the inquiry in question. So, for example, a geologist, as he said, divides fossils not like zoologists into families corresponding to those of living species, but into fossils of the Paleozoic, Mesozoic, and Tertiary periods, and so on and so on. As Venn commented on this, what was achieved by Mill by introducing real kinds was actually it boiled down to saying that this kind of categories tracked uniformities in nature. So this is just another way of saying that they were playing a role in explanations of various kinds, scientific explanations. One important and interesting thing from the perspective I'm going to put forward in a couple of minutes is that kinds are actually both or belong to a larger category, namely the category of either folk or if we think of the general category of kinds, we can let's say distinguish or divide it into at least 2 subcategories. One would be the natural kinds I spoke about, as kinds that are used or utilized or introduced by special sciences. And the other is the idea of kind as a folk category, right? A lot depends on how we understand the relation between the 2. So, for example, Willard van Orman Quine, well-known, a big name in the 20th century philosophy of science, thought that, first of all, natural kinds are based on certain innate quality space, and they're crafted due to certain superficial similarity considerations that most people have. He said, for example, that color is a natural kind because it lies in our innate quality space. But he also said it's distinguished in cosmic circles. What he meant by saying this was that the folk categories were natural kinds, according to him, but then because due to the thesis of the continuity between folk sense or common sense and scientific investigation or scientific conceptualization, he said that actually what we are doing is that we are sorry, because Boyan actually reminded me that I should be ending quite shortly. What we are actually doing, we are crafting kinds from, we are, by means of doing inquiry, we are actually dispensing with natural kinds. So I'm gonna end in 10 minutes, if it's that okay, because we had a kind of a like 10 minutes delay. So the other idea is that folk categories and scientific categories both refer to natural kinds writ large. So it's not like folk terms are superseded by better types of scientific categorizations. And this is the idea of plurality in science and folk categorizing. It was advanced by Dupree, and from this perspective, the interests that are governed, that are shared by folk and scientists are actually equal, even though folk does not always have a purely epistemic interest in dealing with the world as it really is, which presupposedly science does. Well, and the view that I'm trying to discuss with you today is the view proposed recently by Mohammed Ali Khalidi, who says that natural kinds should be projectable, enter empirical generalizations, summarize a wealth of data, feature explanations, and give rise to valid predictions. And he's the one who defends the idea of naturalizing kinds, namely the idea that if natural kinds are classifications introduced for epistemic purposes, folk categories can be expected to correspond to natural kinds only when they serve an epistemic purpose. And one interesting point to make here and to discuss later is whether if the kind law that we are discussing in jurisprudence is a folk category that gets only certain kind of precisation within jurisprudence, or whether this is a kind of specific category, is seen as specific kind of category, which is not folk, but the kind of category that might be seen as scientific, which is crafted by means of any more purely conceived epistemic purposes, not only some purposes of understanding, for example, or governing, but also something more significantly scientific. The view that he proposes is the view of three kinds of social kinds. And the question which seems to be kind of interesting in relation to this kindness of jurisprudence project is whether law, or to which kind law, I'm thinking about general concept of law and its referent, and also particular legal kinds, like the category of contract, the category of felon, the category of murder, the category of parliament, and so on, to which social kind they actually belong. So just to make it very quick, right? There are three categories, he thinks, of social kinds, two of which are good candidates for being natural kinds, and the third one, he says, is not a very good category for a natural kind. So one type of social kinds are those whose existence does not depend on human beings having any beliefs or other propositional attitudes toward them, even though all of these kinds are mind dependent. Think about recession, racism, inflation, or something like this. These phenomena exist because there are people who hold certain beliefs, but these beliefs are not about racism or recession itself, but about certain attitudes toward other people. So in a sense, this kind of phenomena, this kind of social kinds exist because, not because there's some conceptual dependence, but there is just some rough mind dependence, right? The second kind of kinds is those that depends in part on specific attitudes that human beings have towards them, though attitudes need not be manifested towards the particular instances. So in these cases, people need to have certain kind of general recognition, some conceptual idea, even of a folk, even on a folk level of what's the kind about, right? So in order to give rise to this certain kind, most people must recognize what kind of thing the thing is. For example, the good example is money or war, right? And these two types, first and second, are good candidates for natural kinds, Khalidi says, because there are roughly or could be let's say conceptualized as a kind of in a wider network of causal relationships to other things in the world. This is why there is a kind of possible science that we can, real science that we can make about them. So there's a chance for a real inquiry. This is kind of interesting, begins to be interesting when we see him talking about social kinds of the third kind, which are like permanent resident prime minister, which are not good candidates for natural kinds, which would be effectively to say that there is no science possible of this kinds. This would not be science in the sense that we are thinking of science as the most successful and epistemically effective inquiry, but rather it was something different. What's the reason? Because he said that the properties that define dividing our institutional reality into sets of permanent residents, prime ministers, murderers, felons, parties to the contract, and so on, they are not causally, or not causally in a major way, but mostly conventionally linked. So this depends on conventions and concepts, not on the way in which things operate in nature. So this is like this kind of table, as you can see. I introduced a couple of more things here, but this is basically what he was talking about. In case of racism, recession, superstition, art, poverty, or inflation, we have a very strong causal component that constrains the way in which these kinds operate, let's say, in social world as natural kinds, right? Their existence does not depend upon our having certain propositional attitudes about it, and the instantiation of tokens, like particular instances of the kind, also do not depend on people having particular types of concepts or beliefs, right? The case is different with war and money, where some general concept is required in order to recognize or appear a kind of a phenomenon in question. Conflict which is not recognized, at least by some, as a war is not a war. Like, so war, there could be no global error as to whether something is war or not, or whether something is money or not. But in case of permanent residents, prime ministers, felons, jury, murders, contracts, and so on, there is a strong conventional component. As I said, they are concept dependent, and also they're application dependent. The theory is kind of a bit complicated, but yeah, this is the way Khalidi and after him Liam Murphy structure the whole problem. One interesting thing about this, that depending on the context, things described in the third row might turn into those that are described in the second, or it might happen reversibly, namely certain things that have a medium, let's say, conventional component, are concept dependent, but they are not, let's say, application dependent, might be conventionalized by means of legislation. So we can have a general idea of, let's say, property, right, which is a folk concept, and basically one might say that this idea, the general idea of property, cannot exist without people having certain general concept of property, right? But obviously, given concrete jurisdictions, this concept can be more conceptualized, further conventionalized by means of legislation. So we are going to have a more refined kind of property in a given jurisdiction. This is what these guys, Khalidi and Murphy, claim. Obviously, everything depends on the perspective. We are talking about different kinds then when we are actually taking this narrow or wider perspective. And there's one last thing I want to talk about, just 3 minutes, if you let me, namely that there is a difference, or maybe the easiest way to put it would be the following. So where's the law in all of it? Because I already mentioned only particular legal kinds, so to say. So the reason or the response that Khalidi gives, and then this is developed in further papers, is that law belongs to the second type of, so like war or money. This is you need to have a certain kind of concept in order to have law in general. This goes against what Joseph Raz claimed at some point, that there are societies that might not have concept of law but still have law. So they go to the opposite direction. They think that in order to have the social kind law, you need to have a concept, maybe not the refined concept, but at least a full concept of law. And then they dwell together, I mean Murphy and Khalidi, on the problem of disagreements over the kind law. And they say that isn't there a difference between the disagreements over the kind law and disagreements about morality? Where there are. One thing is that disagreements over morality, which are persistent and unavoidable, they say, are not restricted. So the range of relevant related considerations that can be drawn into moral arguments is much, much wider than it's in the case for law as a social phenomena. Even non-positivists and positivists would perhaps agree about this. And the second fact is that law is a particular kind of social kind, and morality, they say, is not a social kind at all. So this is what they say. But in the end, a kind of refined theory and discussion over all these kinds in jurisprudence, and then also general reflection over the concept of social kind law, leads them to the following thesis, which is actually kind of interesting departure point for the Q&A. So they say the difference between positivists and non-positivists is not just at the level of discourse. It has ramifications for the respective kinds that they create. Unlike conceptual differences about morality, which do not have the power to generate different objective moral standards, conceptual differences about the law are capable of giving rise to different legal norms. What they say is that in particular points of application, given the whole overlap, because they obviously say that, well, it might be the case that disagreement between positivists and non-positivists doesn't matter, because in most of the cases, the results, like the identification of norms, is just the same, right? Even though there are two categorization schemes, positivists and non-positivists. What counts as law, what counts as something else, right? But then they come to this point, well, but there are certain differences at certain points. So sometimes they lead to the completely different legal norms. Well, my question is to you in the end, is it compatible with saying that there is one social kind law, or maybe we have actually two kinds in play, which are cross-cutting each other? So there's a kind of, so in result, we would have jurisprudence as a big mess, kind of war between two camps that actually are pointing to very different categorization schemes, or and whether the question is here another, whether really we cannot say if any of these pictures of categorization is privileged. I leave you with this right now. Thank you very much, and yeah, sorry for a short delay. I hope for a good discussion.
Thank you very much, Adam, for your presentation. Now we are going to open the floor to questions. I have already seen one. Professor, I'm so sorry for the pronunciation. Hassan Begovic?
Perfect.
Something on the lines, please.
Thank you.
Hi.
Hi to everybody. Just to start the discussion by clarifying some concepts, I would like to know what is in your perception the difference between the concept of kind and concept of species.
Mm-hmm.
Because we are used, at least in logic, to use the genus and species and categories as the most abstract genuses of all kinds or species, and is it just terminological question or something that has that is grounded in very concept of reality and things you started with?
Yeah, okay, so this is a good question because actually the word kind is supposed to capture all, let's say, taxons in a ladder, namely both species and genus or genuses or whatever are kinds, or might be seen as kinds, right? It's both like a whale belongs to a kind, which is actually a species, but we can also talk about kind of mammals, because we introduce the kind of mammals generally to refer to a certain set of animals that possess or share certain properties because of our scientific interests. Because there's certain laws about mammals, obviously, in nature, and there are also more peculiar laws about the behavior of particular species within that, let's say, genus. Okay, if it's a genus, it's rather not a genus, but in this case, you know what I mean. So the word kind is used just to refer to certain set of properties that are connected in a non-trivial, interesting way, and actually whole taxonomy or classification or categorization is just about identifying kinds. Obviously, there might be on different levels of taxonomy, and there is no problem with this. Yeah, so is it clear, or?
Yes, it's clear. Just the second part, that is the difference between the kind and the most abstract kind, let's say, category, because we cannot put all phenomena, even not in the phenomenology, to one category of phenomena.
Well, one important thing about kinds, just to add, is that the names of particular taxons in any categorization are of secondary importance. We can go with genuses, species, kingdoms.
Okay.
Also, we can go with like general kinds, and then types, and then as I would like Francesco Guala goes in case of artifacts, more particular types and certain tokens, for example, right? This is like of secondary importance. One of the important principles that govern the whole taxonomy of kinds and, let's say, different groupings of kinds and subkinds and so on is the kind of weak disjointness principle. So basically you want to cover the whole area of phenomena, right? It's up to you how you cut the joints. The basic idea from Plato was that these cuts should be like they should be exclusive in a way that if you cut some meat, you cut it into half, right? The point is that if you have different perspectives for individuating kinds, different parts of the body, you might have two butchers who would cut something very differently, and it would be still appropriate. This is why I said this is all the interest relative science. So there might be different criteria at stake for individuating kinds given categorization scheme proposed by someone. And also there might be different criteria for identifying kinds in one taxonomy system. I didn't show it because I don't have time, but there is like an interesting problem whether all fish are fish, for example. It's taken from Khalidi. So we have one kind fish, which has been, let's say, differentiated mostly because of the reasons provided by evolutionary theory, namely the descendants, the common ancestor, right? But as Khalidi writes, there are over 30,000 species that scientists refer to as fish, though they do not belong to a single monophyletic taxon, a taxonomic category that includes all and only descendants of a common ancestor. So this is actually not a homogeneous category. We have like most of the categories in biology like this. There are matters of similarity which are not, let's say, based only on one criterion. So rather than settle for one criterion for selecting kinds, for example, guys try like Khalidi to show that whatever criterion we choose, we just settle for some causal, let's say very roughly speaking, causal mechanism that helps to that makes this kind important in our explanations or making generalizations, right? And that would be it.
Thank you.
Thank you very much. Professor Franeta.
Thank you. Hi to everybody. Do you hear me well? Yes?
Yeah, perfectly.
Yeah, thank you for your interesting lecture. Well, I would like to pose some questions just to try to understand your position better. If we go back to Aristotle, I wonder what would be the place of the possibility in your approach to so-called social facts, like one of the Aristotle's dynamis, one of the categories. And especially if we take into account the Aristotle's epistemology and his division of the knowledge into theoretical, practical, and poetical knowledge, especially having in mind that practical is what concerns what can but must not be. So the place of possibility or dynamis is very important in this realm. So could you please comment that?
This is very interesting. I'm not an expert on Aristotle, but well, I suspect that he would maybe commendate a little this idea that I had, that or I tried to point at one moment, that well, there are both folk categories and scientific, purely scientific categories, and perhaps a merit of this practicalities Aristotle mentioned lies in in seeing the role of these folk conceptions, right? So in a sense, there might be something practical in, for example, I don't know, introducing taxonomy where certain concept of law in general, or maybe with two concepts of law that are quite general. In this way, I'm thinking about this kind of platitudes that people usually share when they are thinking about law, that it's both something that is positive, for example, but also morally relevant in a way. So I need to think about this more, because I just don't want to speculate about what Aristotle would say, or I don't know if that responds to the question at this point.
Well, thank you. I was aiming at this specific properties, attributes of the practical field that in my opinion, could not be equated with the notion of facts. That would be the issue that I was aiming at. So
yeah. So that's why I started to think about this folk categorizations. Yeah, because they do not necessarily, let's say, correspond to facts, right? But rather help with some like typical matters. This is the problem of this epistemic criteria I mentioned, right? Maybe
understanding and decisions. Something like that
so,
in contemporary
exactly. So science is about understanding or gaining knowledge. So it is, let's say, triggered by this epistemic interest, whereas many of folk interests are not epistemic, right? We want to organize our life or feel better, right? Which is not a matter of merely gaining knowledge, but this is also a matter of doing many other things that people do in culture in generally. So this is why I said that perhaps because of this, if we're talking about jurisprudence as actually that would just confirm why jurisprudence is called rather jurisprudence than science. Because in the end,
I agree. Not the science, but the prudence.
Yes, because it is not based on purely epistemic or largely epistemic interests, but rather on interest of rather than cutting through certain type of let's say natural meat, something in the world, we are trying to introduce new conventional area of interest, which is like a kind of important game that we play, let's say, and we are trying to be good in this game, better or worse.
Thank you.
Well, thank you very much. We have a question here, Professor Sponge.
Thank you, Jules. Thank you, Adam, for a great talk. I have been listening to the issues regarding social ontology, especially the issues related to artifacts and law as an artifact for quite a while now. And I have two actually questions. It is fascinating for me to see the development in social ontology from kind of like when we started discussing law as an artifact of kind, it seemed to me too crude of a position. So I was really wondering whether there is a position there at all, and it was also a position on which everybody was agreeing, because it was kind of this an Aristotelian position, and the loads of philosophy was drawn from the 80s, from the 70s, some work on the artifacts. And I was like, while I was following your presentation, I kind of noticed that there is a lot of nuance here, including the nuance regarding the kinds of kinds or artifact kinds that we talk about. It seemed trivially obvious to me that not all law, well, some law is a chair, but not all law is a chair, if you get what I mean, in the sense that there is more to be done in terms of philosophical inquiries in social ontology in order to define the kind of kind that law is, and it doesn't seem to be a simple natural kind. So this was refreshing, and this nuance in the artifact kinds. My kind of question would be, what kind of law? Yeah, I'm saying kinds too many times. What do you think that this will yield in terms of this discussion on the artifactual character of law? And are we able to distinguish within one legal system between those aspects of law that are closer to natural kinds, according, for example, to your Khalid's criteria, and those that are closer to classic artifact concepts and so on? That is the first question. The second question that is very interesting to me, because I read quite a lot of sociologists being angry at social ontologists. But what is, to your mind, the relation between sociology, especially empirical sociology, and inquiries into social ontology? Can do these two things coexist or even help each other, or just we should ditch sociologists completely, we don't need them? Okay.
Yeah, okay. So we should be very tolerant, just to respond to the last question with anybody. But I'm going to get back to this in a minute, because the most important question you asked is the first one, I think. What do we get? What's the bearing of all of this? Well, one thing is that I think the whole bunch of arguments against essentialism that I mentioned at the very beginning show that we are in need of having a certain better, let's say, grounding for thinking about kinds in general, whether artifactual or natural kinds. This is the first point. Second, we need to think about the differences of these kinds. I'm not saying that there are no artifactual kinds, right? So I'm not like fully Aristotelian in this. Aristotle was wrong, by the way, as I said, I think, because it all depends on the, yeah, and I agree with this kind of arguments, depends on the conventionality, the degree of conventionality there, right? Obviously, the thing with kinds in general, also natural kinds, is that like every type of kinds that are of interest of any special science, including physics or chemistry, depend on the paradigmatic categorization that are there. So it's always, everything is interest relative here. And what I learned from this altogether, that first we need to rethink the relation between different types of kinds, natural and artifactual, and second, that there is no interest or unrelative or just objective kind of distinction between them, is that all kinds are, or all classifications are interest relative, is that in the end, even in case of scientific kinds, the most particular types of kinds that science, that are at the very, like, that the basic sciences deal with, like the fundamental sciences deal with, are also a matter of certain kind of negotiation, because they must be agreed upon by the scientists who are engaging in this science, right? So is there any difference eventually? Well, it might only show, and this is what Khalidi also argues for, that the very criterion of mind dependence for distinguishing kinds and then creating kinds is not the best criterion. And actually, this kind of criterion of mind dependence was the first one, and the one utilized by actually Aristotle, right, himself. So we should abandon this. We should try to find some different criteria, and there are some ways of doing it. And one version is what Khalidi tries to present. it does not. If we are, and what's the result of all this? One question is how far we can go with dividing world into natural kinds. So, as I say, the question, as I said earlier, if we have kinds as kind of repeatable causal patterns or properties, as he argues, some nomic predicates that are projectable, which are elements of any systematic inquiry, then one practical result is that we're going to have science understood as systematic inquiry as far as we deal with kinds. So whenever we get into the domain in which we cannot refer to some causal patterns of properties, see how they work in them, and make a systematic theory out of it, then we are not doing science in the proper sense. This is one result, and this is why I said jurisprudence, perhaps at least at some levels, is not science at all, because it's more about. But then again, there's one problem. If particular kinds that we are dealing with, those kinds that are introduced by particular jurisdiction, are dependent upon there being some more general kinds, like kind of law, which Khalidi says is actually a natural kind to a large extent, then in order to be a good engineer in, let's say, domestic legislation, you need to actually be a good scientific thinker who knows how certain kinds work. And I'm saying this on purpose now because I can observe for like 8 years right now that certain general kinds of institutions, let's say, which are well described in the institution of, let's say, parliament, or the institution of judiciary in general, like the court system, something like this. They are being, which we have general knowledge about how this the good judicial system works, right? As a kind of general type of a kind, not as a just a instantiation at some place, but general. We have some general ideas about what makes a judiciary system a good system, right? Just as something makes a state a democratic state in general, for example, then I can see that certain people are actually abusing this knowledge to paralyze the kind, the instantiation of the kind. This is why jurisprudence sometimes, when it's espoused with politics, becomes a kind of bad engineering. I mean, people are using knowledge they have to paralyze institutions, like our constitutional court in Poland is a totally paralyzed institution, because some people use the knowledge they have about the general kind, right, to paralyze a particular instantiation of it. And this is because there is some, let's say, at least partial science about how constitutional courts work and what to do in order to paralyze them. This is what I would say. So, but the general question is to what extent jurisprudence is science, and I think this kind of considerations can help us, at least to some extent, solve this problem of demarcation, basically. And the second question. Should we what was that? It was about empirical sociology and whether empirical sociology can contribute to social ontology. That was the question, Boyan.
Yes, it was the question.
It was the question. Okay, so yeah, I think that in this picture, which is kind of naturalized picture, it should. So sociology, social ontology, should be a kind of general exercise or in categorization of empirical sociology. But this is a kind of reflective relation here again. I mean, there are certain entities, certain kinds, let's say, that are recognized by empirical investigation on the level of groups or populational level. And then social ontology is supposed to conceptualize better the relations, define the laws by means of which different kinds in empirical sociology are connected. So this is a matter of generalization as well. Necessarily it becomes more speculative, but it does not mean that it's not practical as well.
Are you satisfied?
Absolutely. Thank you, Adam.
Thanks.
Okay, I see that we don't have any more questions, so we are like 15 minutes past the end of the session. So thank you very much, Adam, for your presentation.